So I often also come across a lot of people that have estate documentation. They got wills, powers of attorney, personal directives, but it's been maybe 20 years since it's last been updated. Or yeah, they got it done when they had kids, and now the kids are in their 20s or in their 30s, and they're like, oh, maybe we should dust this thing off. So tell me, like, in the last decade or so, has there been much change with how estate planning is done, or anything that we should be aware of how it's maybe evolved over time?
Biggest changes in the last 5 to 10 years are the types of families we have. We have more blended families, the minor children blended families. Those ones are challenging sometimes to work with and to plan with. We also have more adult interdependent partnerships, and the law has changed significantly in that area. So understanding, if I'm going to move in with this person, what is their right to my estate? I've made a great plan. All of my money goes to my kids and my grandkids, and I have a nice amount of money that's going to a charity of my choice. But now I want to move in with this person who I love and I want to spend, the last years of my life with. Well, what's that effect on my estate plan? That's an important question to ask. Leaving that out, not having that discussion, means she might or he might need to make a claim against the estate, which can cause some problems. That's an example of one thing. Digital assets are another thing. Do you have Bitcoin? Do you have any other kind of international? Do you have gaming tokens? And I'm not a gamer, but the gaming dollars and cents and online things. What's your online presence? Are you running a business where you're the administrator of the website? What about Facebook? Are you an influencer and you have assets within Instagram or TikTok that could be revenue for your family longer term? Lots of questions like that are coming up that are different. And digital asset clauses are now typical for us to see in our wills. There are also clauses now in our wills that we put in to be careful and protect inheritances should our beneficiaries separate from their partners. And so there's some law and some new we call them administrative, or some people call them boilerplate clauses in wills that are now pretty standard. But to your question of this person hasn't done it in 20 years, they probably have a really good will. It probably made sense 20 years ago. It probably could work, worst case scenario now, because the minor children's, they're not minor children anymore. They're just getting the money outright because they're over the age of 25. But are we considering the great-grandchildren or the grandchildren? How has our family evolved in the last 20 years? Are the executors that we named then still the right people? Should we be considering whether we bring the next generation into that executorship? Because if my parents live to 100 and I'm 80, my kids might not be the right people to be the executor. It might be the great grandkids or the grandkids that are jumping into that role. Or maybe it's a trust company. Maybe we've accumulated so much wealth that it makes more sense to have a trust company to run that for our family.
And that speaks a little bit to the dynamics we were talking about before, where having kind of that third party sometimes can help eliminate some, sometimes we see family drama, right? And because emotions are high, like you mentioned before as well, people just went through loss, and people want to make sure that the person they love, their wishes are articulated properly.